All right, everybody, this is Brett Thompson again, Thompson Law Group World Headquarters, and we're doing another installment of the hashtag Teaching Tuesday, the Closing Ninja Classroom. Today I want to talk about remedies for a breach, and this episode will be in regards to, hey, my seller has breached the contract. What are my remedies as a buyer? A future video will be, hey, my buyer has breached. What are my remedies as a seller? So, and in this context, we're talking about Virginia law. If I reference the contract, I'm referring to the RAIN contract, which is what the real estate agents here in Hampton Roads primarily use. But this is basic contract law. So, the seller has breached, meaning they have failed or refused to perform in some manner under the contract as promised. And now we've got a breach. What are the remedies for the buyer? So we've got basically two types of remedies. We've got remedies for the monetary damages, all right, and then we've got specific performance. So monetary damages. So the court is going to try to put the buyer in the position the buyer would have been in but for the seller's breach. So any costs, any monies expended in the furtherance of this agreement would be compensatable. So any upfront fees, like an appraisal fee to the lender, any kind of application fees, if they paid for a survey, if they paid for an inspection of the property. So any of the money that the buyer has paid in furtherance of this agreement and in it's called detrimental reliance. So they have relied on the seller's promise, therefore they have expended this amount of money in consideration of their agreement, and now the seller has breached. So any monies that the seller has paid in furtherance to this contract would be recoverable as monetary damages. And those monetary damages have to be a direct and proximate result and foreseeable, reasonably foreseeable. So we're not getting into the realm of, mental anguish and anything abstract like that. In a contract case, it's, hey, let's put the buyer in the position they would have been in but for the breach. So whatever money they paid that was required for this contract, that would be recoverable. If you are a buyer, there's also a second remedy. So in the law, real estate is viewed as very unique, like a unique snowflake, all right? And there's no other piece of property like this. So because of that, because every piece of property is unique, there's also recovery under the doctrine of specific performance. So you can actually file a petition with the circuit court here in Virginia, and you can ask the judge, hey, make the seller sell me the house in accordance with the terms of this contract. So the court can actually judicially force the seller to comply and to convey the property. And here in Virginia, the court could actually appoint a special commissioner to sign a deed on behalf of the defaulted seller in order to convey title to the property over to the buyer. So there's two remedies, all right? So there's remedies for your monetary damages, and you can also execute a petition for specific performance to force the defaulted seller to sell you that house. So that's it. That's a summary of your recovery or your consequences in a breach of contract case in the event you are the buyer and your seller has breached. Next video is going to be, hey, my buyer has breached. What are the remedies of the seller? Thanks a lot, guys.